My name is Celeste Fontaine-Broward. I am 47 years old. I want to start with the courtroom. Not because the courtroom is where the story begins. The story begins 11 years earlier, in the specific ordinary Tuesday afternoon when I was 34 years old and newly separated from my husband and moving into the apartment on Decatur Street in Atlanta, Georgia. And my mother called and said she wanted to help. The specific words that my mother had always used when she was about to do something that would cost me more than whatever the help was worth. But I want to start with the courtroom, because the courtroom is where I understood, with the particular completeness that public moments sometimes produce, everything I had been half knowing for 11 years without the language to fully name it. The courtroom was a federal bankruptcy court in Atlanta. The date was a Thursday in February 4 years ago. I was 43 years old, and I was filing for Chapter 7 bankruptcy protection, the specific legal mechanism available to someone who has exhausted the other options for managing a debt situation that has become unmanageable, not through recklessness or irresponsibility, but through the particular compounding of specific financial events across several years that I will describe fully, including the one I had not yet understood was happening. My mother's name is Vivienne Fontaine. She was 68 years old at the time of the hearing. She was in the courtroom not because she had any formal role in the proceeding, but because I had told her the date of the hearing in the mistaken belief that the information was something she needed as my mother, in the same way that a mother needs to know when her daughter is going through something significant. And because she had driven herself from the house in Decatur, where she had lived for 31 years, to the federal courthouse on Spring Street, and had seated herself in the gallery behind the trustee's table. I did not know she was there until the moment I am about to describe. The bankruptcy trustee, a woman named Margaret Chen, who had been conducting Chapter 7 hearings for 14 years, was approximately 12 minutes into the creditors' meeting, the specific formal proceeding where creditors have the opportunity to question the debtor about the circumstances of their financial situation. The proceeding is typically unremarkable. Most creditors do not appear. The questions are procedural. The entire meeting usually concludes within 30 minutes. At the 12-minute mark, my mother stood up from the gallery. She said, "I need to say something about my daughter's financial management." Margaret Chen said, "Ma'am, this is a creditors' meeting. Are you a creditor of the debtor?" My mother said, "I am her mother. I have been financially supporting her for years, and I have specific concerns about how she has managed money." Margaret Chen said, "Ma'am, if you are not a creditor with a registered claim, you do not have standing to address this proceeding." My mother said, "The court should know that this bankruptcy is the result of irresponsible financial choices. I gave this woman money for years, and she spent it without any accountability, and now she is using the court system to avoid the consequences." The gallery, which contained perhaps 15 people, including several of the other debtors waiting for their own hearings and their attorneys, was very quiet. My attorney, a man named David Park, who had been practicing bankruptcy law for 22 years and who was one of the most contained people I had encountered in a professional context, said in a voice calibrated to be audible to the judge while appearing to be addressed to me, "Ms. Fontaine-Broward, you are not required to respond to statements from the gallery." Margaret Chen said, "Ma'am, I'm going to ask you to be seated, or I will ask the marshals to remove you from the gallery." My mother looked at the judge. Then she looked at me. She sat down. The proceeding continued. I answered the trustee's questions. The meeting concluded. I walked out of the courtroom behind David Park and into the corridor, and my mother followed us. She said, "I want you to know that I am going to contest this. I gave you money, and you wasted it, and I am going to make sure the court understands that." David said, "Ms. Fontaine, your daughter's bankruptcy proceeding is a matter of public record. If you believe you have a creditor claim that should be registered, you may consult with an attorney about your options." My mother said, "I don't need an attorney. I need someone to listen to what I'm saying. I said, I have been listening to you for 47 years. She said, then you know that I have been supporting you financially your entire adult life. I said, I know what you've been doing with the money, Mom. She said, I beg your pardon? I said, I know what you've been doing with the money, all of it. I have the bank statements. She looked at me. I said, all 11 years of them. The corridor was very quiet. David was beside me. My mother was 2 feet away in the specific posture of a woman who has said something she was certain was true and who has just encountered information that challenges the certainty. I said, I've known since the 3rd year. I've been keeping the records since the 3rd year. I wasn't going to use them here. But you stood up in a federal courtroom and told a judge I was irresponsible with money, and I need you to understand that I have 11 years of documentation that says something very different about what has been happening with money in our family. She said nothing. I said, we should talk. Not here. She said, you're bluffing. I said, I'm not. But I'm also not going to have this conversation in a courthouse corridor. When you're ready to have it honestly, call me. I walked out of the courthouse into the February Atlanta morning, and I sat in my car in the parking structure for 22 minutes, which I know because I watched the clock on the dashboard from the moment I sat down to the moment I started the engine. 22 minutes. Before I tell you what was in the bank statements and what happened when my mother called me 3 days later, let me take you back to the beginning. Because the beginning is where the pattern was first visible, even if I was not yet able to see it. And because the beginning is where I first encountered the specific quality of my mother's love, which was a love that had always been organized around what the love gave her rather than what the love gave me. I grew up in Decatur, Georgia, the only child of Vivian and Leonard Fontaine, who had met in 1973 at a church in Decatur and married the following year. The specific ordinary beginning of a marriage in a black middle-class Atlanta suburb in the mid-1970s that carried with it all the particular social context of that place and time. My father was an accountant who had spent 30 years at the same firm in Atlanta, building the particular kind of stable professional reputation that 30 years of good, quiet work produces. My mother had been a bookkeeper before my parents married, and had stopped working when I was born, the specific choice of their generation and their social world. Though the choice was also, I came to understand later, my mother's choice specifically. Organized around the particular advantage she believed she derived from my father's income being available in the way that a full-time homemaker's position made available. I want to describe my parents' marriage accurately, because it is directly relevant to what I eventually understood about my mother and about what she did with money. My father was a good man in the specific, quiet way of good men who do not require recognition for their goodness. He worked 30 years at the same firm. He came home for dinner. He attended my school events and my church events, and the specific events of my childhood with the consistent, unremarked presence of a father who understood his obligations and fulfilled them without drama. He loved my mother in the specific way of men of his generation who loved their wives, which was practical and sustained and not particularly expressive, but thoroughly present. My mother loved my father in a way that I came to understand over time was organized significantly around what my father provided, the particular form of marital love that develops in people, for whom security is the primary emotional need, and for whom the provider of security becomes the object of the love that the security enables. This is not an unkind characterization. It is an accurate one. My mother's love for my father was genuine, and it was also specifically connected to what he gave her, and when he was no longer giving it, the love adjusted accordingly. My father died in 2004 when I was 26. Heart disease, diagnosed 18 months earlier, and declining across that 18 months in the specific way of cardiac disease in men in their early 60s who have not paid sufficient attention to the specific warnings their bodies gave them across the preceding decade. He died at 61 with 30 years of accumulated retirement savings and a paid-off house and a modest life insurance policy, and the particular modest legacy of someone who had spent 30 years doing everything right without doing anything spectacular. My mother received all of it. The house and the retirement accounts and the insurance and the specific small accumulation of 30 years of careful living. The total, at the time of his death, was approximately $640,000 in liquid or near-liquid assets, not counting the house, which was worth approximately $320,000 at that time in Decatur. I am describing these numbers specifically because they are directly relevant to what happened afterward, and because the specific relationship between the amount my father left and the financial trajectory of my mother's subsequent life is the center of this story. My mother was 62 when my father died. She was healthy and organized and perfectly capable of managing her financial life competently for the remaining decades of her life. What she was not capable of, or what she chose not to do, is what I want to describe carefully. My mother was not capable of living within the specific financial framework that $640,000 plus a paid-off house provided, because the framework she had built her entire adult life around was the framework of a woman who had access to money through a provider, not the framework of someone who managed money herself. She had been a bookkeeper before marriage and had not engaged with money professionally in 30 years, and the emotional relationship she had with money was the relationship of someone for whom money was what someone else gave her, rather than something she managed. The first 3 years after my father's death, she spent approximately $280,000, not on anything dramatic. On the specific accumulation of the spending patterns of someone who has always had access to money through a provider, and who has not, in 30 years, developed the internal mechanism that manages expenditure against a finite resource, rather than against an ongoing income. She hired a financial advisor, a man named Gregory Aldis, whose advice was specific, and whose advice she did not fully follow, because following his advice would have required a reduction in spending that my mother was not willing to make. By the time I was 34 and newly separated and moving into the apartment on Decatur Street, my mother had approximately $240,000 in liquid assets remaining and a house that was hers outright. This was still a significant financial position for a 65-year-old woman in Decatur, Georgia, who had no debt and no dependents. It was when she called to offer help that the specific pattern of what I want to describe began. I need to tell you about my marriage before I tell you about the account, because the financial situation that eventually required the bankruptcy filing was partly the result of the marriage and its dissolution, and because understanding that context is necessary to understanding why I accepted my mother's initial offer of help. I had married Marcus Broward in 2004, the year my father died, the specific unfortunate timing of a major life change in the same year as a major loss, which produced in me the particular vulnerability of someone who is managing grief and building a new life simultaneously, and who may, in retrospect, have moved too quickly into a commitment that deserved more careful examination. Marcus was a good man in many respects. He was not the specific kind of good man my father had been, which was consistent and practical and sustained. He was good in the way of someone whose goodness depended on circumstances being favorable, which meant that he was genuinely kind and engaged during the years when things were going well and considerably less reliable when they were not. We separated in 2011. The separation followed 3 years of marriage difficulties that I will describe only in the outline because the specifics belong to Marcus and to me, rather than to this story. The financial damage of the separation was real. Legal fees and the division of assets that are not cleanly divisible, and the particular financial disruption of transitioning from 2-income household to one produced, across the 2 years of the separation and divorce, a specific financial gap that I was not able to bridge entirely on my income as a mid-level marketing manager at a regional nonprofit. My mother called in the second month of the separation. She said she wanted to help. She said, "I want to put some money in an account for you. A joint account, so I can add to it as I'm able, and so you have a cushion while you get through this. I want to be precise about what I understood this offer to mean, because the precision is important to everything that follows. I understood it to mean that my mother was going to put money into a shared account from which I could draw to cover the gap between my expenses and my income while I transitioned through the separation. A bridge, a specific kind of parental financial support that parents sometimes offer adult children in difficult circumstances, and that is organized around the child's welfare. I said, "Mom, I appreciate that. I don't want to drain your savings." She said, "I have plenty. I want to do this for you. Let me do this for you." I said, "How much are you thinking?" She said, "Let's start with $5,000 and see how things go. I can add more if you need it." I said, "Thank you. I'll pay you back when I'm more stable." She said, "You don't need to pay me back. This is a gift." We opened the joint account at her bank, SunTrust, which became Truist several years later when the banks merged. It was a joint account in both our names, which meant both of us could make deposits and withdrawals. This is the specific detail that matters. I went home from the bank that afternoon with the specific grateful relief of someone who has been given a bridge when they needed one. My mother had deposited $5,000. I had the account number and the debit card and the specific security of knowing that the gap was covered for at least several months. What I did not examine carefully enough in that first month was the account activity that was not mine. I want to take you through the specific discovery of what I found in the account, because the discovery was the specific thing that changed my understanding of everything, and it happened not dramatically, but in the specific ordinary way that accounting discoveries happen, which is through the particular focused attention of someone who is checking numbers and who finds that the numbers do not add up. 3 months after the account was opened, my mother had deposited a total of $7,000. I had withdrawn for my specific expenses approximately $3,200. The account should have had approximately $3,800 in it. It had $940. I stared at the online banking screen for a long time. $940. I looked at the transaction history, my deposits, clearly marked, from my paycheck transfers. My withdrawals, each one for a specific amount I recognized as corresponding to a specific expense. And then, between the deposits I recognized and the withdrawals I recognized, a series of withdrawals I did not recognize, not large. $40 here, $60 there, $120 on a specific Thursday that I did not remember withdrawing anything. 37 individual transactions that I had not made, totaling approximately $2,860 across 3 months. I sat at my kitchen table in the apartment on Decatur Street, and I looked at 37 transactions that had not been made by me. I thought about my mother's debit card for the account. I thought about a joint account, which meant both account holders could make withdrawals. I thought about the specific ordinary transactions, amounts that were small enough to be unremarkable in isolation, and that together accounted for the gap between what should have been in the account and what was actually in it. I thought about a lot of things across the 45 minutes I sat at that table. Then I thought about what I was going to do. I did not call my mother. I want to be specific about why, because the reasoning mattered and shaped everything that followed across the next 11 years. I did not call her because I did not know yet with complete certainty what I was looking at. I had a pattern of transactions that I had not made, in a joint account where the other account holder could make withdrawals, and the pattern was consistent with my mother spending money from the account that I understood to be there for me. But I did not have a conversation with my mother on record establishing that the account was specifically for my use and that her withdrawals from it were improper, and without that clarity I was not certain enough of what I was looking at to make a specific accusation. I also thought about the specific thing that happens when you confront a parent about financial behavior without ironclad documentation, which is that the parent denies it or reframes it or accuses the accusing child of ingratitude or misunderstanding. and you are left with an argument that the parents' version of events can survive as well as yours. I was a marketing manager at a nonprofit. I was not wealthy. I was not financially sophisticated in any professional sense. But I had grown up with an accountant father who had spent 30 years handling other people's money and who had communicated, across my childhood in the specific practical way he communicated things, that the most important thing about any financial arrangement was the documentation. He had said once, sitting at the kitchen table with a pile of client files, that the only thing that protected anyone in a financial dispute was the paper trail. I called him in my memory. He had been dead for 8 years. I called him anyway. Then I started keeping records. I want to tell you about the specific nature of what I kept across the following 11 years, because the specificity is the center of this story, and it deserves to be described with the care it actually required. I downloaded every bank statement from the account, beginning with the 3 months that had already occurred, going through every transaction line by line and categorizing each transaction as mine or as not mine. Mine were straightforward to identify because I knew exactly what I had spent and when, and I could match each withdrawal against my expense records, the grocery receipts, and the utility payments, and the specific amounts I had transferred for rent. Not mine were the residual. Every withdrawal I could not match to my own expense record was categorized as other, with the date and the amount and the transaction description exactly as it appeared in the bank record. I created a spreadsheet. I labeled it Joint Account Activity, and I maintained it from that month forward, every month for 11 years, every statement downloaded and filed in a specific folder on my laptop, every transaction categorized, the running total of withdrawals I had not made updated monthly with the specific precision that the work required. By the end of the first year, the total was approximately $12,400. I want to be precise about something. I did not stop using the account. My mother continued making deposits, sometimes larger and sometimes smaller, and I continued making withdrawals for my expenses, and my mother continued making withdrawals I had not made. The account continued operating exactly as it had from the beginning, with both account holders making withdrawals, and I continued documenting everything my mother withdrew month by month and year by year. I also, beginning in the second year, started making deposits of my own. This is the specific detail that I want to be honest about, because it is not a clean story of a daughter who was only victimized and who did nothing else. I made deposits into the account because my mother began telling family members, specifically my Aunt Patricia and my cousin Marcus Jr., and the specific circle of people who constituted our extended family social world in Decatur, that she was supporting me financially through my difficult divorce transition, and that I was struggling, and that she was there for me, the way a good mother was there for her child. The deposits I made into the account were not large. They were the specific amounts I could afford, $300 here and $500 there, on the months when I had a little more than I needed for my own expenses. I made them because my mother was telling people she was supporting me and I was making deposits into the account she was simultaneously withdrawing from, and I wanted the account to accurately reflect what was actually happening, which was that money was flowing in both directions. I also made them, and I want to be honest about this, because there was some part of me that hoped the deposits would discourage the withdrawals, that if my mother saw money coming in from me, she would feel less entitled to take money out. This reasoning was not sophisticated. It also did not work. By the end of the third year, the total of withdrawals I had not made was approximately $31,000. By the end of the sixth year, it was approximately $67,000. By the end of the 11th year, the year of the bankruptcy filing, it was $112,000.47. I had documented every cent of it. I want to tell you about the financial situation that produced the bankruptcy filing, because I think the full picture requires understanding it, and because the full picture matters. I was not, across the 11 years from the account's opening to the bankruptcy filing, a financially irresponsible person. I want to be specific about this, not defensively but accurately. I managed my income carefully. I lived within my means consistently. I did not carry significant credit card debt. I did not make large purchases I could not afford. What happened to my financial situation across those 11 years was the specific compounding of three things that individually were each manageable, and that together were not. The first was the divorce settlement, which required me to assume a specific amount of marital debt that was substantial enough to create a continuing monthly obligation that significantly reduced my available income for several years. The second was a medical situation in the 7th year of the period, a surgery and recovery that was partly covered by insurance and partly not, the specific healthcare cost experience of tens of millions of Americans who have insurance that is adequate until they need it to be. The third was the employment disruption of the 9th year, when the nonprofit where I worked for 11 years lost a major federal grant and eliminated my position, and the subsequent 14 months during which I worked contract positions at reduced income while looking for a permanent position that matched my experience and my income needs. None of these three things was the result of irresponsibility. Each of them was the specific kind of financial event that happens to people who are managing their financial lives carefully and who encounter circumstances that careful management does not prevent. What made the combination unmanageable, which I understand better now than I did at the time of the filing, was the specific ongoing drain of the joint account. Across 11 years, $112,000, withdrawn in the small, irregular amounts that made the pattern invisible in any single month, had created a specific financial gap that was the particular gap between what I had budgeted and planned for and what was actually available to me. I have had a financial advisor, a woman named Barbara Cole, who has been helping me understand my own financial situation since shortly before the bankruptcy filing, review the full 11-year record. She told me, specifically and in writing, that the specific pattern of withdrawals from the joint account was the determining factor in the bankruptcy filing, that without the drain of the joint account withdrawals, the combination of the divorce settlement and the medical costs and the employment disruption would have been manageable within the parameters of my income across that period. She told me that I had been draining myself for 11 years without knowing it was happening, and that the draining was the specific reason I arrived at the place where I arrived. I want to be honest about how I felt when she told me this, because the feeling was complicated and the complexity matters. I felt the specific anger of someone who has been harmed over a sustained period by someone they trusted. That anger was real, and is real. I also felt something else, something more uncomfortable. I felt the particular feeling of someone who had known, for 8 of the 11 years, what was happening, and who had made a specific decision to document rather than confront, and who now understood that the documenting rather than confronting had allowed the pattern to continue for 8 years after it was known. I had made a choice. The choice was to document rather than act. The documentation was now the most valuable thing I possessed in the aftermath, but the documentation had allowed the harm to continue across the years of the documentation's preparation. I sit with both things. They are both true. Let me stop here for a moment because I want to ask you something directly, and I want to ask it honestly without managing it toward a comfortable answer. Have you ever known something was happening and chosen to document rather than confront? And have you sat with the specific complicated feeling of understanding that the choice to document was both the thing that eventually protected you and the thing that allowed the harm to continue? Drop a comment and tell me where you are watching from and what time it is there. Because what happened when my mother called me 3 days after the courthouse corridor is the most important part of this story, and I want you to understand the full weight of what preceded it before I tell you what was said. If you have not subscribed yet, please do. My mother called on the Sunday after the Thursday hearing. 3 days. I had been waiting. She said, "I've been thinking about what you said." I said, "I know." She said, "About bank statements." I said, "Yes." She said, You don't have bank statements from a joint account that prove anything. You have statements that show withdrawals, which were my withdrawals, from my own account, that I have every right to make. I sat with this for a moment. This was the specific version of the response I had anticipated, the framing in which the joint nature of the account made every withdrawal legitimate, regardless of the specific agreement the account had been opened under. I said, "Mom, I want to be precise about something." She said, "Go ahead." I said, "The account was opened at your suggestion, in your words, to give me a cushion while I get through the separation. You described it as money you were putting in for me. You told me at the time and in subsequent conversations that the money in the account was for me. I have documentation of that." She said, "You don't have documentation of any conversation we had. You can't document a conversation." I said, "I have documentation of a specific email you sent me 2 months after the account was opened in which you described the account as your way of making sure I had something to fall back on. I have the email." She was quiet. I said, "I also have the 11 years of account statements. I have a spreadsheet, maintained monthly since the 3rd month after the account was opened, that categorizes every single transaction in that account as either mine or yours. The withdrawals categorized as yours total $112,000.47. She said, "That's..." I said, "Let me finish." She was quiet. I said, "I also have documentation from my financial advisor that the specific pattern of withdrawals from that account, the amounts and the frequency and the sustained period, was the determining factor in the financial situation that produced the bankruptcy filing. The bankruptcy that you described in a federal courtroom as the result of my irresponsibility with money?" She said nothing. I said, "I have everything, Mom. 11 years of everything. I have it organized and I have it filed, and I have had a financial advisor review it and put her analysis in writing." She said, "Why didn't you say anything?" I said, "Because I was hoping you would stop." She said, "You kept records for 11 years and said nothing and hoped I would stop." I said, "Yes." She said, "That's," I said, "complicated." "I know." She said, "Why are you telling me now?" I said, "Because you stood up in a federal bankruptcy hearing and told a judge in a public proceeding that I was irresponsible with money, in front of people I don't know and my attorney and the court record. You said that in a courtroom. I am not going to let that stand without the full context being available." She said, "You could have told me years ago." I said, "I could have. I chose not to, because telling you would have required a confrontation that I was not able to have without the documentation being complete, and because every time I considered having it, I thought about what it would cost our relationship, and I decided the documentation was the right path." She said, "And now?" I said, "Now you have made the relationship cost something in a federal courtroom, and the documentation is complete." She said, "What are you going to do with it?" I said, "That depends on this conversation. I want to describe the conversation that followed because it is the specific, most important part of this story, and because it requires honesty about what was said by both of us." My mother said, "I need to tell you something that I have never told you." I said, "Then tell me." She said, "When your father died, I understood for the first time what the money meant, not as something he provided, as something finite, something that was going to run out." She said, "I had been a bookkeeper before we married, and I had not thought about money professionally in 30 years. When he died, I hired Gregory, and Gregory told me what the numbers were, and I understood that the numbers were finite and that I did not know how to make them last." She said, "So I spent them." I said, "I know." She said, "And then when you called about the separation, I saw something. The account." I said, "Say it specifically." She said, "I saw that there would be an account with money coming in that was separate from my account. And I told myself that I was helping you and that I deserved to use some of the account because I was the one who started it, and because I was your mother, and because..." She stopped. I said, "Because?" She said, "Because I was scared that the money was going to run out, and I kept thinking that if I had access to this account, it was money that wouldn't run out as fast. I said, "You took money from an account you told me was mine because you were afraid you didn't have enough." She said, "Yes." I said, "You told everyone you were supporting me financially." She said, "I was." Some of the money in the account was mine. I was putting money in. I said, "And you were taking more out." She said, "Yes." I said, "For 11 years." She said, "Yes." I said, "And last Thursday in a federal courthouse, you said that the bankruptcy was my fault." She said nothing for a long time. She said, "I was scared that the court would find something. I thought if I said something first, it would—" I said, "It would redirect attention." She said, "Yes." I said, "To me." She said, "Yes." I held the phone and I thought about the specific question that had been sitting in the back of my mind since the 3rd year. The question I had never fully answered, even in my own private thinking. I said, "Mom, did you know what you were doing?" She said, "What do you mean?" I said, "Did you know that the withdrawals you were making from that account were the reason I was having financial difficulty? Did you understand that there was a connection between what you were taking out and what I didn't have?" She was quiet for a long time. She said, "I didn't think about it in those terms." I said, "That's not the same as not knowing." She said, "No." I said, "Tell me what you thought about." She said, "I thought about the account balance. I thought about whether there was enough in the account that I could take what I needed without leaving you without." I checked the balance before I took anything. I said, "So you knew the balance was lower because of what you were taking?" She said, "I didn't think about it that way." I said, "Mom, you just told me you checked the balance before making withdrawals to make sure there was enough left for me. You were monitoring the account. You knew what you were doing." The silence on the phone lasted for 2 full minutes. I counted. She said, "I was afraid." I said, "I know." She said, "What are you going to do?" "I want to tell you what I decided, and I want to be honest about how I arrived at the decision, because the arriving was complicated, and the complication is part of what makes this story worth telling honestly." I consulted with David Park, my bankruptcy attorney, about whether the documentation I had built had any relevance to the bankruptcy proceeding itself, whether the pattern of withdrawals could be presented in a way that affected the outcome of the case. He reviewed the spreadsheet and the statements and the financial advisor's analysis. He said the documentation established a clear pattern of unauthorized withdrawals from a joint account held under specific representations about its purpose, and that this pattern could be characterized in several ways depending on the jurisdiction and the specific legal theory applied, ranging from breach of fiduciary duty between co-account holders to unjust enrichment to, in the most aggressive framing, civil fraud. He said, "You have something here that is legally significant beyond the bankruptcy proceeding. Whether you want to use it is a separate question." I said, "What would using it accomplish?" He said, "Potentially a civil judgment against your mother for some portion of the $112,000. Potentially a modification of the bankruptcy proceedings characterization of the debts if her withdrawals could be shown to be a contributing cause of the filing." I said, "What would it cost?" He said, "Emotionally, significantly. Financially, several $1,000s in attorney fees minimum. Relationally, everything that remains in the relationship with your mother." I said, "And if I don't use it?" He said, "You have a record. The record exists. It documents what happened. Whether you use it in a legal proceeding is separate from whether it is true." I said, "David, tell me honestly, what would you do?" He said, "I would use it to have one completely honest conversation with my mother, and then I would decide based on what came out of that conversation." I had already had that conversation. I thought about what my mother had said. The fear. The account balance checking. the specific admission that she had been monitoring the account to make sure there was enough left for me after her withdrawals, which was the specific admission of someone who understood exactly what she was doing. I thought about the courthouse corridor, the public statement, the judge. I thought about my father at the kitchen table with his client files, saying the only thing that protects anyone in a financial dispute is the paper trail. I thought about 11 years of spreadsheets, maintained monthly, every transaction categorized, the running total updated with the specific precision that he had communicated was the right way to handle anything financial. I thought about what I wanted, not what I was entitled to, not what I could prove. What I wanted. I called my mother 2 weeks after the Sunday phone call. I said, "I've decided what I want to do with the documentation." She said, "All right." I said, "I'm going to present it to you formally. A complete account of every withdrawal you made from the joint account across 11 years, with dates and amounts and totals. I'm going to give you a copy of my financial advisor's analysis, showing that the withdrawals were the determining factor in the bankruptcy filing." I said, "I'm going to present it to you as a formal accounting of what occurred, not as an accusation in a legal proceeding, not as a lawsuit, as the specific record of what happened between us financially across 11 years. She said, "And then?" I said, "And then you're going to decide what you want to do about it." She said, "I don't understand." I said, "What you did had a specific cost. I have documented the cost. I am presenting you with the documentation. What you do in response to being formally presented with the documentation is your choice." She said, "What are my choices?" I said, "You can acknowledge what the documentation shows and accept the responsibility for the role your withdrawals played in my financial situation. You can make some or all of it right financially if you are able to and choose to. You can choose to say you disagree with how I've characterized it, and we can have that argument with the full documentation on the table. Or you can do nothing." She said, "And if I do nothing?" I said, "Then I will have the complete documented record of what happened, and you will have made a specific choice about how to respond to it, and we will both know what that choice means about what kind of relationship we have going forward." She said, "You're not taking me to court." I said, "Not at this time." She said, "But you could?" I said, "Yes." She said, "I see." I said, "Mom, I want to tell you something about why I'm doing it this way." She said, "Tell me." I said, "I kept those records for 11 years, not because I was preparing to destroy you. I kept them because my father taught me that documentation was the only protection available to anyone in a financial situation, and because I understood from the 3rd month that something was wrong, and that if I was ever going to be able to say clearly and specifically what was wrong, I needed the documentation to say it with." I said, "I maintained the record because it was the truth, because the truth deserved to be recorded. And I'm presenting it to you now, formally, because the truth also deserves to be acknowledged by the person who was part of making it true." She said nothing. I said, "What I want, Mom, is for you to sit with this, the full accounting. I want you to sit with what it shows and what it cost me and what you said in that courthouse and what you knew when you said it." She said, "And then?" I said, "And then we will see if there is anything left to build between us that is honest enough to be worth building." I mailed her the accounting the following week. A formal document, 31 pages, every transaction, every month, every total, my financial advisor's analysis and conclusions attached. I sent it certified mail, return receipt requested. The specific small professional gesture of a woman who had spent 11 years learning that documentation mattered. She signed for it on a Thursday. She called me on a Saturday. She said, "I read it." I said, "All of it?" She said, "All 31 pages." I said, "What do you want to say about it?" She was quiet for a long time. She said, "I want to say that I am sorry, specifically. Not, I'm sorry you feel that way. Not, "I'm sorry things worked out this way." I am sorry for what I did, for 11 years of doing it, for what it cost you, and for what I said in that courtroom. I said, "Thank you for saying it that way." She said, "I have some money left. Not much. Gregory told me last year I had approximately $90,000 remaining between accounts." She stopped. "After 30 years with your father and 20 years of—" She stopped again. "I have $90,000 in the house." I said, "I know." She said, "I want to give you half." I sat with that for a moment. I said, "Why half?" She said, "Because what I took was $112,000 and I don't have $112,000. I have $45,000 I can give you, and I want to give it to you." I said, "You would have $15,000 remaining in the house." She said, "Yes." I said, "Mom." She said, "Don't tell me I don't have to. I know what I did. I know what it cost you. I want to do what I can do." I said, "I need to think about this." She said, "Take whatever time you need." I said, "Can I ask you something?" She said, "Yes." I said, "When you made those withdrawals, were you thinking about me at all?" She was quiet for a very long time. She said, "I told myself I was. I told myself you had plenty and the account had plenty, and I was just taking what I needed and you wouldn't even notice." She said, "But I knew I was checking the balance before I took anything, and I knew the balance was lower because of what I was taking. And I think if I'm being completely honest, which I am trying to be, I think I knew what I was doing, and I told myself a story about taking care of myself that let me not think about what I was doing to you." I said, "That's the most honest thing you've said to me in 11 years. She said, "I know it's late." I said, "Yes." She said, "Is it too late?" I thought about my father at the kitchen table with his files. The only thing that protects anyone in a financial dispute is the paper trail. I thought about 11 years of monthly spreadsheets. I thought about what Barbara Cole had said. "You have been draining yourself for 11 years without knowing it was happening." I thought about what I had said to David Park, not what I was entitled to, not what I could prove, what I wanted. I said, "I don't know if it's too late. I know that the $45,000, if you choose to give it, will be received and will make a specific practical difference and will be documented properly, and the documentation will show what it is and where it came from." She said, "I want to give it." I said, "Then give it." She said, "And after?" I said, "After we will see what there is to build." The $45,000 came through in March. Barbara Cole oversaw the transfer and the documentation of the receipt and its proper handling within the bankruptcy proceeding, where it was relevant as an asset that affected the case's final accounting. The bankruptcy case closed in May of that year, 4 years ago now. I have spent the 4 years since building. I want to tell you what building has looked like, because I think it is the most important part of the story, and the part that matters most to tell. I used a portion of the $45,000 to clear the remaining bankruptcy-related obligations, and to establish the specific financial baseline that a person coming out of bankruptcy needs to begin building credit and financial stability from scratch. I worked with Barbara Cole on a specific plan, the particular detailed financial plan of someone who has learned, through very expensive experience, that planning and documentation are not optional but foundational. I returned to work in a new position, at a marketing consulting firm, where I had the particular advantage of someone who had 11 years of experience in the field, and who arrived at the position with the specific clarity of someone who understood exactly what they were good at and exactly what they wanted to build. I have been building for 4 years. Not everything I had before. Something different. The something I am building now is organized around what I actually want and what I actually have, rather than around the specific gap between what I was trying to have and what kept not arriving, which is the gap that, I understand now, the 11-year drain had been producing without my understanding what was causing it. I have a savings account with a specific balance that I update in a spreadsheet once a month. Old habits. My mother and I are in a relationship that I want to describe honestly, rather than with false completion. We speak once a week. The conversations are careful in the specific way of two people who have said true things to each other that cannot be unsaid, and who are trying to find what is real and sustainable in what remains of their relationship. She is 72 years old. She lives in the house in Decatur. She is healthy. She has $15,000 remaining, and the house and the particular modesty of a woman who has spent down most of what she had and who has done some of that spending through a joint account she was draining from her daughter, and who has to live with knowing that, across the remaining years of her life, I do not think she is a bad person. I think she was a person who was afraid, and who handled fear in a specific way that caused specific harm, and who understood what she was doing while telling herself a story that made it possible to keep doing it. This is not a description of a monster. It is a description of someone capable of self-deception in the specific way that people who are afraid of running out of something are capable of self-deception. I also know that she stood up in a federal bankruptcy courtroom and said things that were specifically completely untrue about my financial management, and that she did it knowing exactly why she was doing it. I hold both things. I am learning to hold both things. Here is what 11 years of a joint account and a monthly spreadsheet and the paper trail my father told me to keep taught me. I know that the most important thing my father ever told me, the most useful single piece of advice he gave me in the specific practical way he gave advice, was the specific sentence about paper trails. He said it about client files. He did not know he was also telling me something that would become the specific protection available to me in the most significant financial harm of my adult life. He said it and I remembered it, and when the moment came that required it, I knew what to do. I know that documenting rather than confronting is a choice with a cost. The cost is the years during which the harm continues while you are building the record. The record eventually becomes the most valuable thing you have. The years during which the harm continued because you were building the record are years you do not get back. Both things are true simultaneously. I know that financial harm, when it is perpetrated by someone who loves you, has a specific quality of confusion that financial harm from a stranger does not have, because the love is real alongside the harm, and the love makes the harm harder to name clearly, and the naming is the prerequisite to addressing it. I could not name clearly what my mother was doing for a long time, not because I didn't see it, but because naming it required naming something about her that I was not ready to name. The documentation gave me a language for it that did not require me to name it before I was ready. And I know that the paper trail, the 31 pages of monthly statements with every transaction categorized and totaled, the financial advisor's analysis, the certified mail with the return receipt, was the specific thing that made the most honest conversation I have ever had with my mother possible. She could not have had that conversation without the documentation in front of her. The documentation made the conversation necessary. The conversation, however painful, made what comes after it possible. My father kept files for 30 years and told me the only thing that protects anyone in a financial dispute is the paper trail. He was right. I keep the spreadsheet still. Not for this account, which is long closed. For everything. Every month. Every account. Every transaction. He is gone. The lesson is not. That is my story. 11 years of a joint account. A monthly spreadsheet updated the first Sunday of every month. A federal bankruptcy courtroom and my mother's voice saying the specific wrong thing in the specific wrong place. And the 31 pages that made the only true conversation we have ever had about money finally possible. If this reminded you of a time when keeping a record of something was the only protection available to you, and you kept it anyway, not knowing yet what it was for, I want to hear from you. Drop it in the comments. Share this with someone who needs to know that the paper trail is not only for courtrooms. It is for the specific moment when the truth needs to be shown to the person who helped create it. Hit subscribe. and I will see you in the next one.